and the average person scores 1 or 2, the average defendant goes into 3 or 5, and then it gets narrower as that goes on.
Thank you.
Okay. So given this background, and especially given the heinous offense, it was especially important that the sentencing be clean. But the judge misapplied the statutory impulsivity factor. He equated impulsivity or impetuosity with a split-second decision. But the statute requires the ability to consider, quote, the risk and consequences of behavior. Graham has very similar language. And the inability to weigh long-term consequences describes this case pretty well. My client was meandering along a road, burglarizing this house and that, and at the end committing this horrible sexual assault, all with no escape plan. Of course it was impetuous and impulsive. Second, the trial court applied blanket policy. It found that deterrence is always a consideration in any sentencing. And while it's certainly common, nothing is always in sentencing. Every case must be unique.
Well, counsel, I don't understand what you're just arguing. While every case is unique with regard to applying the various sentencing factors for a particular defendant, how can you say that deterrence is not a consideration in every criminal case?
I mean, it can be consideration in any criminal case, but
Why isn't it always a consideration in any criminal case, along with other potentially aggravating or mitigating factors?
Well, it's theoretically can be a consideration in any case or every case, but a judge has to apply it and find facts in any specific case, and it may or may not.
But that's a different point.
Okay.
The question is, did the trial court properly consider the aspect of deterrence?
Right.
Is different than saying deterrence is not a proper consideration at all, which is how you began.
Oh, it's definitely a proper consideration, but it has to rely on the facts of the case. There may be a case in which deterrence is irrelevant. For example, a type of offense where that's unique, that no one else would be in that situation. So it's always a statutory factor, but it's got to be based on the facts of the case, is all I'm saying. So
also, with regard to this question of impulsiveness,
yes,
I'm not sure I understand what your point is. It seems that you're arguing that it was not carefully planned what he did on the night that these 3 different home invasions, but once he got to the victim in this case, what was impulsive about that? Wasn't that a lingering, terrible night of abuse that she suffered?
it absolutely was. And if my client had given one thought to his own, forget about the moral and obvious heinous implications of this. If my client had given the slightest thought to his own self-interest, he would have done no such thing. And that's what Graham is about. Graham is saying that children do not possess the same ability to control their actions or consider their actions that you or I do. And so there has to be different, because it doesn't say it excuses certainly, but it says there has to be certain different considerations there.
So you're arguing he couldn't control himself when he was engaging in this terrible behavior?
Well, I'm arguing that certainly he was unable to control himself is maybe too broad, but he was certainly unable to consider the long-term consequences to himself, or he would never have done it.
Well, how many criminals of whatever age? I mean, it seems to me this is a characteristic of serious criminals in any context who commit serious crimes. Their long-term thinking is always suspect. They don't consider much of anything, as opposed to the opportunity to commit a crime and then to do it. What's distinctive?
That is often true. But both Graham and the legislature have said that the ability to consider long-term consequences has to be one sentencing factor. It doesn't mean it's the only sentencing factor. It doesn't mean you can't get a long sentence, but it has to be one sentencing factor. And I'm saying the trial court did not apply it correctly.
What part of this record supports the claim that this defendant didn't understand the overall bad consequences for him if he gets caught having committed these terrible acts upon this woman?
The part of the record that said that afterwards he was driving aimlessly and then meandering along the road, holding the proceeds, to having no heed to the consequences on himself, let alone
Now,
anybody.
my focus is as he was engaging in this terrible behavior,
Right?
what indication was there at that time that he somehow didn't understand that there would be serious bad consequences for him if he were caught?
Well, I don't think during that time that I can tell you anything, but afterwards, what he did afterwards is circumstantial evidence that at the time he wasn't he did not have considering that. That would be my answer to that. So unless there are any other questions on issue
Go
two,
ahead.
issue one. Okay. Now the state argues primarily, so what? He got the minimum. But as we argue in issue one, the minimum 72-year sentence violates Graham v. Florida. I'd first note that unlike Miller, which covers homicide cases, Graham flatly banned life terms without meaningful parole for non-homicide cases, absent a, quote, realistic opportunity for release. The term realistic is not in Miller, it's only in Graham. But under Illinois' parole framework, Massey can rehabilitate himself until he's Mother Teresa, yet the board can, and probably must, deny parole forever. That's true for three reasons. First, under the administrative code, if parole would deprecate the seriousness of the offense, the board must deny parole, no matter the rehabilitative change. Second, the parole statute deems facts aggravating, which under Graham must be mitigating. Emotional instability for one, and substance abuse for another. And third, parole is arbitrary. While the board must consider all kinds of factors, it can then deny for any reason or no reason. It's purely a matter of grace. That's what the Hanrahan case says. All of which undermines Graham and Montgomery, which make rehabilitation primary. Now, the state argues that Spencer holds otherwise. In Spencer, our Supreme Court found that the parole statute satisfied our proportionate penalties clause. But Spencer did not address the Eighth Amendment, except to distinguish it. It did not address juveniles, especially for non-homicide crimes, except to distinguish them. And it addressed neither Graham nor Montgomery, nor except to distinguish it, Miller. So our argument is that it does not follow that what is a meaningful opportunity under the proportionate penalties clause is a meaningful opportunity under the Eighth Amendment. Alternatively, even if this court, yes, Your Honor.
Counsel, the
Yes.
state is correct, this is not that the trial court imposed, the sentence imposed in this case was the minimum required by statute.
I'm sorry, could you repeat? I didn't hear the first part.
Is the state correct that the sentence the court imposed in this case is the minimum required by statute?
Looking only at the statute is correct because of the yes.
So your argument is we'd have to conclude that under the circumstances of what happened in this case, the sentencing was unconstitutional because otherwise this is the minimum sentence. So it's not a question of the court abusing its discretion by imposing too heavy a sentence, is it?
That's correct. That's correct. We're certainly not arguing that the sentence is excessive. You know, as is the common in terms of the run-of-the-mill excessive sentencing. We're not arguing that at all. Under the proportionate, yes, we're not arguing that.
So if we conclude the sentence is not in violation of the Constitution, case is over, is it not?
Well, it is not, and that's what I'm getting to. That's what I was going to say. I have an alternative argument on that.
Okay.
Even if the court disagrees with issue one, if it finds improper sentencing factors, this court should still remand because on remand, this court, the trial judge, could find that Massey's sentence violates the proportionate penalties clause. Now, one thing that Spencer recently clarified, which I don't think was at all clear before, that emerging adults, like all other defendants, may raise proportionate penalties claims as to sentences of any length. So even if Massey's sentence isn't de facto life, he can still make a proportionate penalties claim. Now, on remand, counsel could make a credible argument that the mandatory minimum violated the proportionate penalties clause under the Illinois case of People v. Leon Miller. In Leon Miller, as I'm sure you all are aware, the defendant, a minor, was convicted of 2 murders that got mandatory natural life. 3 converging statutes made this sentence mandatory: the transfer statute, the accountability statute, and the mandatory sentencing statute. Here, my client's sentence was also mandated by the confluence of three statutes. Again, the mandatory sentencing statute, the mandatory consecutive statute, and the 4 mandatory consecutive 10-year add-ons for using a knife, even though he did not consecutively use a knife, he used it at one time. So that's not an independent argument, but it is an argument that if this court finds that the sentencing factors were improper, it would not be harmless and it would still be worthwhile to send it back to the trial court. So unless there are any other questions on that, I will go to Krankel. Your Honors, in his motion to go pro se, my client made several complaints against trial counsel. The first, addressing guilty plea negotiations, involved his first lawyer, Ron Lewis. I'll get back to that one in a minute. But his remaining allegations simply discussed counsel, and they were equally applicable to not only Lewis, but also his private counsel. I believe his name was Spears. Failure to investigate witnesses, failure to file a suppression motion, and failure to file a severance motion. Both of his counsel could have addressed could have filed these motions as they all appeared pre-trial. But this was a perfectly legitimate Krankel complaint, and the judge inquired into none of this. Now, as the state points out, Massey also did specifically target his first attorney, Ron Lewis, arguing that he mishandled the plea bargaining. The judge did not inquire about this either, so for these reasons, this court should order a Krankel inquiry. And unless there are any other questions, I'd ask that this court grant the relief we requested.
Thank you, counsel. Mr. Goldman, on behalf of the state, you may make your argument at this time.
Thank you, Your Honor. I will address the arguments in the order in which counsel raised them, starting with the argument related to the sentencing factors. I think that the core issue here for the defendant's argument is that the defendant already received the minimum allowed under the law. The court, which is evident from the record, was very careful in the way that it addressed the factors. It did not breeze through them by any stretch of the imagination. It carefully considered each of them, and it reduced the sentence to the lowest possible amount allowed under the law. And I think your honors are correct that absent a constitutional violation, that was the most that this judge could do. So any complaint related to misapplication of impulsivity or some other factor really doesn't play a role in this case. What this is really about is they receive the minimum sentence, and is that minimum sentence constitutional? I would argue, obviously, that it is, but I would say that the question about the application of the individual factors is more or less a distraction from that core constitutional issue. But addressing impulsivity, because that was something that counsel discussed at length, the way that the defense is construing impulsivity here is in a very broad manner. Practically nobody would be committing serious crimes if the criteria for impulsivity was your ability to think about your future. Nobody would murder anybody. Nobody would ever commit criminal sexual assault under these circumstances. Every single person who would be convicted of a serious crime would be almost by definition impulsive. I think when we look at the actual analysis of impulsivity and impetuousness, we see 2 things. First, impulsivity or impetuousness as part of the character of the defendant. Somebody who actually lacks development in that part of their brain, is has some kind of difficulty making those decisions, or impulsivity in the moment. And I'm unfortunately not able to recall the specific name of the case, but I know that one of them is one where there's essentially a drug deal gone bad. Somebody's a lookout, they attack the person, and then when the person wakes up, they hit him with a bat or something of that nature. That's the kind of situation where even though it takes place over a series of interactions, each of the moments happens very quickly. The person wakes up, they're struck with the bat. That's very different from the kind of impulsivity that the defendant is claiming in this case, where certain aspects of it may have been impulsive. Doing a home invasion possibly could be impulsive. And had the defendant, upon encountering this young lady in her home, hit her and ran out the door, perhaps that would have been an impulsive act because it happened in a split second. But under these circumstances, where the assault at issue took place over the course of a long period of time, that is time where the defendant's impulsivity did not play a role. That is a time where the defendant had time to think about what was taking place, make a different choice, and he carried on with the assault anyway. Your Honors, turning to the core constitutional issue raised in the defendant's first argument, uh, I would argue that the Spencer decision resolves this issue. The Illinois Supreme Court was very clear that the parole review scheme established by the General Assembly is a meaningful opportunity for release. Now, it is true that there are things that make the defendant in Spencer different from the defendant in this case. Obviously, the defendant in Spencer falls into the category of what people describe as an emerging adult, somebody between the ages of 18 and 21, whereas this defendant was under the age of 18 at the time the offense was committed. But those factors actually make it more likely that this individual would have an opportunity for meaningful release, because all of the factors that the court is directed to consider apply more to people if they're younger. The court is supposed to consider those factors related to the juvenile mind, and changes that can take place as that person reaches adulthood and thereafter. And so uh, the fact that the court determined that a 20-year-old has a meaningful opportunity to release under this parole review statute means that this defendant has an equal or perhaps even a slightly greater chance at an opportunity for release. Now, counsel brings up possible problems with the parole review scheme, but I would argue that the Illinois Supreme Court was able to take a look at parole review and determine that it still is a meaningful opportunity for release. And under the law, that is what the Constitution requires. Your Honors, if there are no further questions on that issue, I'll turn to the Krinkle issue.
Let me just make sure I understand, it's, there's this new parole statute that is been enacted. Is it your position that's applicable in this case and sufficient for the defendant's purposes?
Yes, Your Honor. I think it's probably agreed by the defense as well that this is applicable. They acknowledge that after 20 years, the statute will allow them to get parole review. And then I believe it's every 10 years thereafter, they get additional review should they not get the relief that they seek the first time around. That appears to apply in this case, and the Illinois Supreme Court has said that constitutes a meaningful opportunity for release, which is what is required under the Constitution.
I understand Mr. Ornstein's argument, however, he's claiming that the decision of the parole board denying parole, if that were the case, could be arbitrary and there's no restraints on it and no judicial review. What about that?
I disagree that it's arbitrary. Certainly they do have discretion, but they look to a series of factors in order to determine whether or not the person should be eligible for parole. And I think that the concern that the parole board will have to essentially rubber stamp a denial of parole due to the circumstances of the offense likely isn't correct because I think when interpreting the statute, the parole board will probably determine that the legislature was able to create this scheme for people who are accused of very serious offenses. I mean, essentially, anybody who's going to be eligible for this is going to be somebody who is convicted of murder or, in a case like this, very, very serious sexual assault or some other similarly heinous crime. And so it seems very unlikely to me that the parole board would say, well, if we grant parole, even though we're explicitly supposed to consider it, we have to deny it in this and probably every other case because we're looking at heinous crimes here. The more likely thing is that they will look at the specific aspects of each individual offense and determine, is this something that the defendant has been rehabilitated from, that the defendant has changed their character in, and is this something where they can be released into society now, which is exactly what the law is written for, and exactly, uh, I would argue, the right way to treat juvenile offenders, where there is the possibility that they could change down the road. That's what the statute hopes for. That's probably what the General Assembly hopes for, and that's something that the parole board will have the opportunity to review at this parole hearing.
You may continue.
Thank you, Your Honor. If there are any other questions on that topic, I'm certainly happy to answer them, but otherwise I'll move to the Krenkel argument. The Krenkel argument here, I believe the core issue with the defendant's argument is that the defendant received multiple different attorneys throughout the life of this case. Krenkel is an important issue when the claims raised by the defendant concern the attorney that is representing them at the time that they would have the post-trial motion. Now, I would argue that some of the claims that the defendant now raises in this argument are actually forfeited. The defense counsel in their initial brief really only addressed one claim, and that was the claim related to their pretrial counsel regarding the plea negotiations. In my brief, I then pointed out that they had completely different counsel, which made it so that Krenkel was not a problem for the post-trial issues, for the post-trial motion. And then counsel brought up additional claims that the defendant made after the trial. I would argue that those claims are now forfeited because, as your honors are well aware, you are required to bring up all of the claims that you want to be heard in your initial brief. But in any case, the situation with the different attorney pre-trial, the different attorney at trial, and then that trial attorney did represent the defendant for some time post-trial, but ultimately sentencing was done by a different attorney. All of these different attorneys mean that the concern of the attorney having to argue their own effectiveness simply wasn't present in this case. Counsel does bring up the fact that the sentencing attorney might have felt some pressure to not argue the ineffectiveness of their superior in their office. But I would argue to this court that in my experience, is not a particular concern for public defenders. That public defenders are interested in defending their clients and would not be dissuaded by that. It's just a matter of my personal experience having been a public defender. But the ultimate issue, though, is that the only claim that was raised in the initial brief should not have posed a problem for Krenkel, and all of the other claims are forfeited, and for that reason, this court should reject that claim as well. Unless the court has any other questions, I'll simply stand on the strength of my brief as written, and thank you for your time.
I see none. Thank you, counsel. Mr. Ornstein, on behalf of the appellate, you may make your rebuttal argument at this time, sir. You're muted, Mr. Ornstein.
Apologies.
Slide.
Let me get my right screen up here. So, a couple of things. First of all, right at the outset, counsel noted that the judge reduced the sentence to the lowest amount possible under the law. And so we agree with what counsel said, that absent one of the two constitutional issues I brought up, that it couldn't be reduced any more than that. But there's a flip side to that. Because you reduced it to the lowest possible amount under the law, if you remand under the constitutional issues, there's a reasonable chance that the judge might go lower, because the judge already went as low as a judge can go. The second point I would make is that under the counsel's argument of impulsivity, a split-second situation, a quick home invasion, a robbery, no sexual assault could possibly be impulsive. Everyone takes at least a few minutes, but that can't be the law under Graham, which specifically distinguished sexual assault or rape, or the term they used, from homicide, and said that homicide aside, everybody either gets not a life term or a life term with a realistic opportunity for parole. Finally, I wanted to address what you said, Justice. I believe it was just Justice Steigman asking about if the state thought the parole scheme was arbitrary. Our argument isn't exactly that it's arbitrary, but it elevates a policy decision that violates the policy principles of Graham. Under the Illinois Administrative Code, it's very clear, both under two separate sections, that if the offense is serious enough to deprecate that, a shorter term would deprecate the seriousness of the offense, you can't grant parole no matter any other consideration. And that is the problem with Graham. Says that everybody has to have a realistic opportunity for parole. Finally, as to Krenkel, I would just say, as far as the forfeiture, give me one sec. I'm reading from my opening. I totally disagree with the forfeiture. I'll read a sentence, two sentences from my brief. Before his sentencing hearing, Massey moved to go pro se. In the motion, he alleged that counsel never investigated witnesses, improperly agreed to continuances, failure to seek burglary charge severance, failure to seek weapons evidence suppression, and failure to address, and I'm paraphrasing, the Gerstein hearing. And then I went into Ron Lewis and the sentencing offer, which is the issue the state is talking about. So I would say that we forfeited nothing in our opening brief. So for those reasons, we ask that this court remand for either resentencing or alternatively for a Krenkel hearing.
Thank you,
You
counsel.
mean-
We'll take this matter under advisement, issue a ruling in due course, and we'll stand in recess at this time.
Thank you.